The Honourable Member for Saanich Gulf Islands.
Thank you, Mr. Speaker. I'm returning to a question asked in question period on October 18th, just last fall, 2023. And the question was immediately upon, well, 5 days after, the Supreme Court of Canada ruled that sections of this government's bill on environmental assessment, which they redubbed impact assessment, which came forward through Bill C-69, were struck down by the Supreme Court of Canada. Now, I practiced environmental law. I'll briefly share with the Chamber that I actually worked in the Mulroney government and took a draft environmental assessment law through the Privy Council to get permission for our government of the day to bring forward the Canadian Environmental Assessment Act, which ultimately entered into force around 1993. It went through several changes. It was an excellent piece of legislation. It worked well. It was repealed under an omnibus budget bill under the next government, not the next government, but Prime Minister Stephen Harper's government, and it was struck down and eliminated by Bill C-38 in spring of 2012. This was more than lamentable. When the new government came in 2015, the current Prime Minister gave a mandate letter to former Minister of Environment, Catherine McKenna, to fix this. Tragically, she ignored the advice of environmental experts, even those that she had impaneled. So what I asked on October 18th was whether the new Minister of Environment, Minister of Justice, would follow the excellent advice of the expert panel on environmental assessment law, chaired by former chair of the BAP, the Bureau d'Audience Publique du Québec, Joanne Gélina, and many environmental law experts, and thoroughly supported, certainly by the Green Party and by myself, that we follow the advice that the essence of environmental assessment law is to evaluate those projects of the federal government itself. At a minimum, the panel said federal land, federal money, where federal permits are issued, and another additional list of concerns. Tragically, the government ignored that advice. They took the advice from the Impact Assessment Agency itself. And what I asked the minister back on October 18th was, would the government now, with the chance, the excellent opportunity created by the court, as I completely predicted it would, striking down the sections that were based on the designated project list, itself a creation of Harper's Bill C-38, a terrible way of weakening environmental law, and at the same time, failing to honor federal jurisdiction. The minister missed the point of my question and merely said that they were going to fix it. I'm desperately worried they're going to do a quick fix. And the quick fix, once again, they'll listen to the advice of the wrong people. I beg the Parliamentary Secretary to tell us tonight that the government will follow the advice of the expert panel that gave them the right road to fix environmental assessment law in this country.
Recognize the Honourable Parliamentary Secretary to the Minister for the Environment and Climate Change and the Minister for Sport and Physical Activity.
Thank you, Mr. Speaker, and I thank my honourable friend and colleague for the question tonight, and I hope that her working virtually doesn't mean that she's not feeling well. I hope she's well. And I thank the honourable member from Saanich Gulf Islands for raising this important fact and for highlighting one of the reasons why I chose to get involved in politics, and that was because of the disastrous environmental policies of the Stephen Harper government that put our country's reputation internationally in peril, and it also put in peril our most vital natural and most essential natural resources, which is our natural environment, Mr. Speaker. This government conducted extensive public engagement sessions in the development of the Impact Assessment Act, and I'm happy to speak to some of those actions this evening. At the time, the government heard from a range of individuals and organizations, not just environmental lawyers, but also Indigenous groups, the public, industry representatives, and academics, all of whom provided invaluable input into the creation of the impact assessment regime. My colleague also reminds me that the rules introduced through the Impact Assessment Act on assessing major projects were needed to address issues that had been identified with the former legislation, the Canadian Environmental Assessment Act of 2012, which I can say from personal experience in Milton was a disaster. This government heard from Canadians who were calling for the restoration of public trust and confidence in the environmental assessment process, and enacting the Impact Assessment Act was the necessary change to provide predictability, accountability, and transparency. The Supreme Court of Canada's opinion on the constitutionality of that act does not discredit the process this government has made in protecting the environment, nor does it undermine the federal government's ability to exercise leadership on environmental protection. In fact, it confirmed that Parliament can enact impact assessment legislation. The Supreme Court also confirmed that the overall structure of the Impact Assessment Act is sound. The Court also provided clarity and direction to further refine the Impact Assessment Act's process to ensure that it meets Canadians' needs and values, as well as Canada's unique constitutional requirements. The government recognizes that responsible development is critical to the prosperity of our country, and that time is of the essence with respect to projects that are currently in the impact assessment system. As the government lays out a plan to make more amendments, it will continue to listen to Canadians and uphold commitments to mitigating climate change, transitioning to a green, sustainable, net zero economy, and respecting the rights of Indigenous peoples. Mr. Speaker, the government is working quickly and diligently on introducing targeted and meaningful proposed legislative amendments required to provide regulatory certainty for major project proponents, Indigenous peoples, and investors. We will continue to work collaboratively with provinces and territories, Indigenous peoples, industry, environmental groups, and the public to determine a path forward for environmental assessments in Canada, and we will remain committed to providing clarity for all our stakeholders and Indigenous partners, upholding Indigenous rights, protecting the environment, and growing our economy all at the same time. To this end, Mr. Speaker, I issued a statement on the interim administration of the Impact Assessment Act to provide guidance, and on the Interim Administration Act to provide continuity for proposed projects in the impact assessment process. And amending the Impact Assessment Act continues 50 years of federal leadership in impact assessment, and this remains a priority for the Government of Canada and for the Minister of the Environment and Climate Change. Thank you, Mr. Speaker.
The honourable member from Saanich, Gulf Islands.
Thank you, Mr. Speaker. Here's the tragedy. Again, the government ignored the advice of the experts it had impaneled. And let me just stress that the extent of public consultation undertaken by that expert panel was extraordinary. Hearings in every single province and territory, thousands of witnesses in person, as well as the advice. This advice was ignored by the former Minister of Environment, and tragically, that led to parts of it being struck down. I'm making it very clear as I can in the 30 seconds I have left, that if this government rushes and puts amendments in the Budget Implementation Act in the spring, it's very vulnerable to the criticism that it has not consulted. Its only and strongest protection is to rely on the advice that came from the panel chaired by Joanne Gillinas, to rely on that because it was the product of extensive consultation and thoughtful review of key pieces of legislation. The advice it's getting right now, I hear through the grapevine, is the wrong advice once again. Thank you.
Then I have Deputy de Milton.
The honourable member for Milton.
Speaker, the Supreme Court of Canada's opinion provided new guidance on the Impact Assessment Act while affirming that the federal government's leadership role in environmental assessment legislation is critical. The Government of Canada also developed the Impact Assessment Act to create a better set of rules that respect the environment, Indigenous rights, and ensure projects are assessed in a timely way, and we remain committed to those principles. But, Mr. Speaker, I just left the Environment Committee a little while ago. Over the course of 2 hours, we heard from 9 different witnesses, and I would say that there wasn't necessarily a consensus on all issues with just 9. So when the process was undertaken to hear from thousands of Canadian stakeholders with respect to environmental protection, it's important to note that there's no way to develop a full consensus on every single issue, but deep consultation is a priority of this government, and it will continue to be as we reassess the Environmental Assessment Impact Act. Thank you, Mr. Speaker.
The honourable member from Spadina, Fort York.
Mr. Speaker, on November 6th, I had